Hi everyone, we're going to be starting soon. We're just going to let everyone be able to enter into the room. All right, let's get started. Hello everyone and welcome to KPA's family webinar. Just so you guys all know, the people who are in front of you, I'm Emily Banks. I practice family law and as well criminal law, and I'm the family law manager at KPA. And we're going to go to Preet.
Hi everyone, I am one of the partners at KPA. Ryan is behind the scenes working on our IT, and I practice family law. Karishma?
Hi everyone, my name is Karishma. I am a family lawyer here at KPA and I also practice in employment law.
And
Hello, thank you, Emily. Hello everyone, I am Barbara Kaye and I practice family law, but I also practice real estate law.
All right, Ryan, if you could start the slideshow for me. All right, so just a little bit about KPA. It's our firm in general. We practice almost all forms of litigation. So right now we're only going to be talking about family law, but you can always get in touch with any but of our lawyers at KPA. We do family law, human rights, employment, cannabis law, criminal defense, debt collections, civil litigation, and liquor license and small claims. We have multiple lawyers and we also have a paralegal on staff. And just so you know, we're all located at 200 Matheson Boulevard West with Suite 100. Right now, we are currently closed to the public unless there's something urgent that needs to be done, but we are doing free consultations over the phone or via Zoom. So you can always book a phone call or a video conference with any one of our lawyers to do a free consultation.
We're missing one of our family lawyers today, Sasha Ferrone. She usually joins us, but at the time she is very busy to be on the webinar with us. So if you wish to book a consultation with her, you may also do so.
And just so everyone knows how this is going to work, if you have a question, you can please put it into the Q&A so that anyone, all panelists can see it. We can also answer your question both orally as well as a written. If it's an easier question and we can write you an answer, we'll do so as well. If you are putting it in the chat, it's only going to some of the panelists and we have to check it. So it's best to put your questions into the Q&A section. If you do not want to have your name put on, you can change your settings so that you are anonymous so no one can see who you are. Also, we're allowing anybody to become part of the matter, and all you have to do is put your hand up, and when we see you, then we'll click on you and you can talk to us and tell us your question, and we'll see if we can answer the best for you. It may take us a few times to get to your questions. We're going to try to get to anyone who has their hand up as soon as possible, but we may take some of the written questions in between people who have their hands up, just so it's fair to go around, since some people don't want to have their voice or their video up for everyone to see. Now, we do this because we are going to be posting this webinar on social media after. It's also going to be emailed to everybody. So if you do not want to have your name or your face shown, please make sure that you have changed it to anonymous. Also, if you don't want to ask your question, but you want to listen in, then you can do so. And then you can always book a free consultation with one of us afterwards. Ryan, can we get the next slide? All right, so these are the different ways of dealing with family law matters. So on the one side, you have the easier and less time-consuming matters. So you can have kitchen table discussions, which is when both you and your spouse are having discussions about how to divide up your property, how to deal with custody and access, that kind of thing. The next one is what's called lawyer-lawyer negotiations. This is what we also call four-way meetings. So when you each have counsel, and you have counsel trying to help you come to some form of negotiation. At the end of that, you come to a separation agreement that both parties would sign. It would deal with all matters. It can be filed with the court for support purposes. The next is mediation, which is where you have either both clients and their lawyers, but lawyers don't have to attend. And then you have a mediator, and the mediator will try to help negotiations, but they cannot make decisions for you. They will help you to work out problems, but if you cannot come to an agreement, then no agreement would happen in mediation. The next is mediation arbitration. Now, at that time, you have a mediator who will help try to do negotiations, but once the negotiations have failed, then they turn into an arbitrator, and arbitrators can make final decisions. Then you go to the farther in the spectrum where you have just plain arbitration, where you're going to be submitting your proposals, and then the arbitrator will be making decisions based on the evidence before them. And the last one is court. If there's really no way to negotiate, then you start with a court matter. This is usually the case when there is some form of abuse in the matter, because you can't really have proper negotiations when there's abuse, or if the other party refuses to participate. Next, we're going to start doing some of the questions. So Ryan, if you can stop sharing the screen. And
Thank you.
we
So
have questions. Oh,
Go ahead.
sorry.
Go ahead.
We have some questions that have been emailed to us previously, so we'll be mixing those in with the ones that we're answering that are being asked right now.
All right, so I'm going to read out the first one from our anonymous attendee. 13 years ago, I got married. Over the next 2.5, 3 years, we separated 3 times. So in the almost 3 years, we were together half the time. It was never me that initiated the separation. For 11 years, there has been no contact. Can I get an uncontested divorce after 11 years apart? Anybody want to take? All right, I'll start. So in order to be separated, you have to show the court, in order to get a divorce, you need to show the court that you have been separated for 1 year. You are allowed within that 1 year to reconcile live together or get back together for 90 days at the most in order to try and reconcile your marriage. If that's not successful, those 90 days can be counted towards your 1 year separation. So in your, our anonymous attendee has asked if 11 years of no contact can allow her to get an uncontested divorce. I don't see why not, unless there are circumstances that you have not disclosed to us in writing. My short answer to 11 years apart, no contact whatsoever, I don't see why you can't get a divorce.
Okay, just before we go on, there are people who are writing in the chat. Please ask your questions in the question and answer, so it's easier for us to keep track if we're answering them. And Ryan, Diane has her hand up. Hi, Diane, you just need to unmute yourself. You're still muted, Diane.
Diane, on your bottom left, there should be a button that says mute with the microphone. If you hit that, there you go.
There you go.
Got it? Okay, so I have a post-secondary education court order that he is to pay. Now, if my daughter continues school, which she wants to go for 1 year for paralegal, is he obligated still to pay?
This is kind of on a case-by-case basis. It depends on different situations. If she doesn't take any breaks between school going forward, then that goes towards he should be paying for it. If you and your husband have postgraduate degrees, then that goes towards that he should be paying for it. If you have the court order that he has to continue paying support, and then you don't stop it, and he continues to pay, then it's up to him to decide to bring a motion to change or contact you in order to stop it.
Okay, so he has to bring the motion to change in court.
Or he can contact you and ask you to end it. You can start doing some negotiations, and if you decide you're going to stop it, then you can tell FRO yourselves, and not have to go through court and have to go through that time and expense.
Diane, is this the paralegal degree? Is this right after high school?
She's going into 3rd year at Brock University.
Oh, and then paralegal.
And then she's going to do a year at paralegal, and then probably she'd like to work a year to see if she wants to continue to be a lawyer. So she's kind of going down that route, right? And I just wanted to know, like, I have a court order saying, because he would never pay, so I had to actually become my own lawyer and go through courts, and he would never show up to court. And the problem was that I finally got a court order and got child support for all of that. And then two, my next one was when I went through the court system and he would never show up, the judge never cleared the financial part of it. He just felt that because he wasn't at court, he should have his time in court, but he would never show up to court. So my thing is, we've been separated 7 years, divorced a year. Is he still legally obligated to come after my pension, even though he cashed his whole pension in and spent it all?
So there is time limitations on bringing equalization. It's 2 years after divorce or 6 years from date of separation, but you've also already started the court matter, so that has, you've already passed like the limit, you've reserved the limitation. But he would be like, even though he's already spent his pension, it's based off of what was the assets and debts on the date of separation. So he would be responsible for that money.
So he still actually legally can come after me for my pension?
If
As
your
long
court
as-
matter is
yeah.
still going, yeah.
Yeah.
And if that does happen, because he spent all of his, how do I deal with that? Like, how do I go after him?
Well,
No-
you would also have his pension would still, like, the value of his pension is the date of separation. So even
From
though he
when
doesn't
that
have that money, he should have that money. And so that is accounted as if he did have that money.
Okay, so they would look at that as well, if that ever goes down that road.
Yes.
Correct.
Okay, that's it. No, that's good to know. Thank you.
Not
You're
a
welcome.
problem, Diane.
Thanks, Diane. Okay, so there's a question in the Q&A, and it's
Sorry, 1 second, Karishma.
Oh.
Ryan, can you let Diane leave?
Yeah.
Okay.
There we go. All right,
Okay.
sorry,
There we go.
Karishma.
That's okay. So there is a good question here, and it's kind of a general question, and it's about legal aid and whether there's a cap for legal aid fees. And, you know, we get this question a lot. We do accept legal aid clients, and there is a cap on legal aid. The certificates are usually for 24 hours. And so we ask most clients to just be mindful about, you know, how we're spending those 24 hours. We can ask legal aid for more hours, but it's up to them and their discretion. So hopefully that answers your question on that.
So there's, Barbara, do you want to take one of the Q&A questions that were sent to us in the emails?
Yes, let's see one of the pre-sent questions. So this one is from Lindsay. The question was, do I need to pay my ex-wife for loans she claims we made together, or do we have to go to court if I disagree on paying anything? I disagree paying for these loans, as she left me with just as much debt in visa debt, and she has the marital home that we lived in together for 5 years. So the rule in family law is upon separation or divorce, the assets of the marriage are equalized. So despite who created the debt and how much debt, if it was something that occurred during marriage, it would be a debt for the purposes of evaluating your net family property. So having said that, however, if the debt is not for the benefit of the marriage, like for example, debt that's a result of one party gambling or one party having an alcohol addiction, there could be an argument for unequal division.
Thank you,
All right.
Barbara.
And just to continue on that, if the debts are incurred after separation, then it would be dealt with differently. As well, if the debts were incurred not for the benefit of the family, then there could potentially be a claim for unequal division based on that debt, but it is a very high threshold.
Ryan, can you let Patricia in? Thank you. Patricia, you're going to have to unmute your mic. Again, like we mentioned. Oh, there we go.
Hi,
Hello?
Patricia.
Yeah, I'm here. Can you hear me?
Yes, we can.
Okay. So my question is, what's the difference between a separation or a legal separation? I don't know if those are really one and the same, and a divorce.
I can answer this one.
Go for it.
Everyone, it's really funny when we're live. Everyone just stares at each other. So there's not actually a legal separation per se. A separation can be the date where one party says to the other party, you know, I want out of this relationship. It could also be the day that one party goes to the bank and separates their finances. It's essentially the day where both parties establish that the relationship is over, the marriage is over. There's no legal piece of paper that says you're now separated. Versus a divorce is, of course, you know, you're legally divorced. You are now able to remarry, and you get a certificate of divorce in the mail that you can hang up if you want on top of your fireplace, whatever you want to do. But there are small differences in terms of how the date of separation is important. It's because the date of separation is, you know, the date where support payments might commence, child support, spousal support. If you're married, then it's the date that your assets will be equalized on, and that's the date we use. So while there's no legal separation, it is a very important date in family law.
But you have to go through a lawyer to officially mark that date.
Not necessarily. Emily, did you want to say something?
Yeah, I was going to say the exact same thing. Not necessarily. You can say it to each other and then put it in writing to each other and have that done. But we suggest that in order to make sure that you've covered all of your bases in your separation is to hire, at least one of you hire a lawyer to draft a separation agreement so that you know that everything is tied up properly.
Okay. Okay. All right. I always thought that a separation was the same as a divorce, except you couldn't get remarried with one and you could with a divorce, but I guess I was wrong.
Part of it.
That's also true. You can't get married with just a separation.
Patricia, many clients, in fact, stay separated forever. They have no interest in getting a legal divorce because they don't feel the need to remarry. So,
Right.
Right.
So really, if we're both mutually in agreement, I could just get a legal or a separation or a legal separation because I don't have any ideas about getting married again. And then that would be fine. Yeah.
Yeah. You just do a separation agreement to make sure that all of your assets and debts are taken care of and you don't lose any of your rights. And then you don't need to worry about him ever coming after you for anything. And then go your own ways. And then if one of you eventually wants to get divorced, you can just file the paperwork.
Right. If things change and for some miraculous reason, you make it right.
Exactly.
All right. Thank you.
Thank you, Patricia.
I just want to mention, I do note that a lot of people are posting their questions in the Zoom webinar chat. If I can request that you paste your questions in the Q&A at the bottom of your screen, you should have a few options that tell you what you can do. And the option that I wish for you to choose is the one that says Q&A. And if you can write your questions under the Q&A section, it's easier for us to answer them there than have to read a few different chats.
Thanks, Preet.
So
Okay.
I do see a question in the Q&A, if you don't mind my taking it.
Go for it.
The question here is, if two people, specifically a boyfriend and girlfriend, bought a house together and one of the family members, presumably of either the boyfriend or girlfriend, offered a gift of money to them and the other person has left the relationship, is that money protected to the party that received it? So to be clear, you're boyfriend and girlfriend, so you're not legally married, so there's no automatic right to any of those funds, but also as boyfriend and girlfriend, maybe you slide into common law, but nonetheless, anything you bring into a common law relationship, you bring out with you. So the assets are typically what you bring in, you take out. So I would say, yes, that money would be protected, but if anyone else wants to add a little nuance to that.
So it could be if the gift was used to purchase the property and there wasn't any documentation that it was a gift, that could cause issues of trying to exclude it from the division of that property. You generally, for gifts to go forward, especially when they're from family members, and for it to be excluded, you're going to need some form of documentation.
There's always a way to bring some property into the relationship, and there's ways to exclude it. As lawyers, we are taught to fight for our client, no matter which side of the coin the client is on. So if you have anything in specific to ask about whether your relationship even qualifies as a common law relationship, there are some rules and the law that allows us to determine if you are a common law couple or not. Let's take one from this anonymous attendee. I would like to modify the custody agreement. At what age can a child ask to stop scheduled visits and the other parent through a child lawyer? I was told age 12 with good reason. Is this true, and what is considered good reason? So I often hear this age 12, age 13 number, and I've never seen it in actually the Family Law Act at any point, unless my colleagues have. It is something that's devised by the practice of law, and we do often see that a child who is capable sometimes is capable at a certain age to decide what they want to do in terms of seeing their parents, either mom or dad, or mom and mom, or dad and dad. So there are times that the court will allow a child to come in and kind of give their opinion through the children's lawyer or through the OCL. But oftentimes judges do like to see that a child is seeing both parents through their childhood.
So the reason why it's there is that Section 24 of the CLRA, so that I'm blanking on what the actual name is. Children's Law Reform Act. No, always talk in short forms. But it's in Section 24. It describes what is in the best interest of the children, and one of the considerations that the court looks at is what is the preferences of the child. However, they take that with a grain of salt, as Preet was saying, with how old they are, if they have the amount of responsibility and
mental stability,
that kind of thing, to make the choice, or to see if of what they're saying is being influenced by one of the parents. So that's when either CIS can get involved or OCL can get involved, which is the Office of the Children's Lawyer. But if the Office of the Children's Lawyer gets involved, that is at their own discretion. The court can ask them to, but they can decide to take the file or not. Usually if a child is, 12 to 18, somewhere in there, they have their own cell phones, that kind of stuff, and can say on their own to their parent if they want to see them or not. So that would be taken into consideration even if you didn't have the OCL involved.
I always say a child who's 12, you can't really pick them up and force them into a car to go see mom or dad for access. So it becomes very difficult. Courts aren't there to tell you how to do things that are unrealistic. They're there to see how realistic a family can move forward with the life they have.
Also,
so, yeah, go for it.
I'm going to tack on to that. There are also, instances where a court might look at, well, does dad or mom have they been in the child's life for the last 6 or 7 years, or has the child seen a parent be abused at the hands of the other parent? They'll take that kind of stuff into consideration when the child is old enough to, as Emily said, be able to think for themselves and decide on their own whether or not they want to be involved.
So as everyone can probably see, Emily and I and Karishma can debate about this for hours, depending on the age of the child, depending on other circumstances. So if, again, you have a question that's very specific to your personal matter, I would suggest call in, book a consultation, speak to us in a little bit more depth, and then we could get some more fact situations from you and understand what your personal situation is and advise you accordingly.
Thanks, Preet.
No problem.
All right, there's a question in the chat. I'm a little confused of what the question's asking. It says, what are my rights after being with my husband for 31 years of being married? Reason being is my husband doesn't support me. All he pays is my car payment and rent. I've been with my partner for 36 years. I feel I have no rights and always work to live independently. From this question, it seems to me that you're still with your husband. And if you are still with your husband, then everything he has, you also have. So you have access to his bank accounts, and you can, if you need to pay things for your lives together, then you can, this is shared money. If you are separated, that creates a different issue, and we would be talking about if you're entitled to spousal support or not, and that has multiple different facets as well as the time you've been married.
So for our attendees, I could do a quick lesson on how equalization works from marriage to separation. So what our court system and our law does is we take assets on the date of marriage and we subtract your liabilities on the date of marriage. And we do that same math equation for the date of separation. So obviously it's important to determine what your date of separation is. So we do your assets minus liabilities on the date of separation. Then we take the difference of those two numbers for one person. And we do the exact same calculation for the other person, and we come up with a number. The difference between the two end numbers, whoever has the higher number will pay the other party 1/2 of the difference in equalization. It's a simple math calculation, but it can take very long to. I just read a question. Why did we become family law lawyers, or why did we become lawyers? Sorry, I got distracted. So yes, so it's a simple calculation, back to what I was talking about, equalization. However, it can get complicated depending on the types of assets, depending on what exclusions there may be. Matrimonial homes are treated differently. Pensions, RESPs, TFSAs, RRSPs.
It also gets very confusing if someone is a business owner, they're self-employed, they're attributing income to themselves, et cetera, because then we get into income analysis and all that. So as Preet said, it's a math calculation, but a very, very complicated math calculation.
I wanted to mention this earlier too. So I know it can get expensive. And as I'm saying all of this, some people in our attendee list may be like, holy, this is complicated and perhaps I need a lawyer. And perhaps you do need one, but there are alternatives to hiring a lawyer on a full-time basis. And at KPA, we do provide you that option. So what that option is, we allow you to hire us, but on a limited scope basis. What that does for you is that we do all the back-end work for you. We do all the court preparation, all the documents, and you save yourself money by providing us the basis for those documents to prepare the actual court record, and also representing yourself at court if you wish to do so. Or in the alternative, what we can also do is do pretty much what I'm trying to say is that we can do limited services for you through your entirety of the court matter. So you don't have to hire us from the beginning to the end. You can say, I want to do some things myself. I want to speak to the judge myself. I want to do my case conferences myself. But what I do need you for is to prepare the case conference brief, to prepare the court documents and get them filed at the correct time, at the correct way they need to be, so that I'm not looked down upon when I am in court.
That is true. All right, so we have another question here that was sent in earlier. So I do not live together with my partner at all times. We don't have the same address. However, we have been together for over 5 years and have properties together in both of our names. In the law, are we considered common law spouses? Without a will, do either of us have a right to the other one's properties that aren't under both of our names, especially considering children are involved? So in Ontario, common law spouses are individuals who have cohabitated in a conjugal relationship for 3 consecutive years. Or if you've had a child together, you've cohabitated in a conjugal relationship for 1 year. So it's not quite clear if you've had children together or not. Maybe there are other children, but based on the information provided, if you've lived consecutively together for 1 year, then you would be constituted as common law. But having said that, it doesn't mean you're protected in the sense that you would have automatic rights to a home that isn't in your name as a common law partner. So if you have a common law spouse and you both own property or own property separately, I would suggest adding yourself to title or setting up a cohabitation agreement, which would set out what your intentions are with any assets you have, or simply having a will prepared to identify your intentions with the properties.
All right, to go off of that, we have quite a few questions about division of a property with common law spouses.
Yep.
So as we discussed, when you're married, you have a right to equalization. So all assets and debts from the date of marriage to the date of separation will be divided. You do not have that right as common law spouses. You have to then look at common law rights which is things like a joint family venture and trusts and constructive trusts. So if a party is not entitled to a property, let's say they've been living together for 2 years, only one party is on the title, but both parties have been equally contributing to the maintenance and the cost of the house, then they can make a constructive trust claim to say that they're entitled to at least a portion of that property. Sometimes it's divided specifically based off of money that has been put in. That's usually easier to do when the relationship is shorter. But you can also be attributed money from the property based on everything else that you've done that isn't actually monetary. Things like doing all of the cooking and cleaning and caring for the children, all of that kind of stuff. It can be monetized. So these are more difficult cases where you're going to have to look at your entirety of your relationship and who's been paying for what out of all of your assets. So it is possible for someone who is not on title in order to get portions of the property through common law. If you're entering into a common law situation and you want to either protect yourself if you are the asset owner, or if you guys want to make sure that everything's going to be equal when you do separate, or if you do separate, then we suggest doing a cohabitation agreement. So it's all set out beforehand when you are happy with each other. It costs a lot less money to do that than to go through separation proceedings and trying to make common law claims to the courts. Those are lengthy and usually pretty expensive.
Thanks, Emily. Do we have any hands up? I can't tell. Do you know?
No,
we
we
don't.
don't.
Okay.
We don't.
So there's a Q&A, and I have a 3-year-old girl with an uncooperative mother. She struggles with mental health and becomes defensive when inquiring about my daughter. There are times where she's unstable due to her mental health. She's currently denying and restriction communication between my daughter and I. How do I inquire about my child's safety? There's a no contact order against me. So this individual cannot call his ex, and communication is via third party only. So first and foremost, if your access or parenting time is being denied or restricted, this is definitely means to bring a court application, because there's no reason why you should be all of a sudden restricted on your time with your daughter. If you have concerns about your child's safety, you can always, and my fellow panelists can jump in, but I understand you can always contact Children's Aid Society and have them get involved if there are concerns. Children's Aid Society will do a report, will investigate, and accordingly will do a report or will withdraw if they cannot find anything. So definitely, if you find that you're having serious concerns about your spouse's or your former spouse's mental health and she's not letting you see or speak to your daughter, I would highly recommend, contacting one of us, book a consultation, and getting that fixed right away.
And also, if even despite COVID-19 and despite the court's limited access right now, your matter would be considered on an urgent basis, and the courts will hear you if you are being denied access to your child.
And this is assuming that you had access prior, and then all of a sudden you are now not.
Correct.
For some reason. But either way, it's quite serious, and as Preet said, it would be considered urgent.
Or if you're recently separated.
Yeah.
And that's why you're no longer seeing your child.
Right.
Correct.
So there's another question that says, am I responsible for the credit line debt on the business line of credit? I believe this one depends on if you're married or because in common law, unless you're been part of the business, you're not going to be able to claim for part of the business. If you're married and you're claiming for equalization of the business, then part of the business debts is also part of equalization, because it would be part of what the value of the company is. It also comes into play if that line of credit is being used for more than just the business, and it's actually being used on household or family expenses as well. I'm not sure if anyone else wants to join in on that.
So actually that question, thanks, and that question was also emailed to us. So that's a really good, and just to clarify your point, it does say my husband owns a substantial amount of business line of credit debt. So another thing to consider is also whether you will be claiming half of the interest in the business. When that debt was incurred, whether it was before, during the marriage, or after the marriage. And the second half of that question is, he also owes CRA debt, and would you be responsible for that? Similar answer. Do you want to tack on?
Nope, pretty much the same thing.
Okay.
CRA debt would be debt within the marriage, because you benefited from the income that he had, and that's why they had CRA debt. So since you benefited from the debt, you would also be responsible for the debt.
Thank you.
All right. How about we answer the fun question of why did we choose to become lawyers?
Should we go in a circle and answer?
Sure.
Just joking.
I'll start. I've wanted to be a lawyer since I was a kid. Took the classes and as many classes as I could in high school. As my father always likes to say, I was arguing with him about how many peas I'd eat. So that's just kind of continued throughout my life. And that's what I knew what I wanted to do. So I went straight from high school to university to law school and articling, and started at KPA before I even got fully called to the bar. So that's my story.
It was fated. Well, I can go then after you. So mine was not as straightforward as Emily's. My undergrad was in art history and English literature, so it was a lot of argument formulating and writing. And I always enjoyed it. I liked the creative aspect to it. And when I left university, I found I just wasn't being challenged enough. And again, it goes back to the arguments. I ended up going to law school to continue learning and improve my arguments. So I can have better conversations now, and I can help represent people. But yeah, no, it was not a straightforward path for me.
I became a lawyer because I became a lawyer. I have no idea how to answer this, but I continue to be a lawyer because I enjoy helping people in my community, and I enjoy family law more so than any other area of law because it allows me to become friends with my clients. It allows me to help my friends, and that's that.
Wow, this is a tough one to follow.
I
with you
know.
guys. Yeah. Why did I become a lawyer? I think it's pretty badass. I don't know if I'm allowed to say that on live webinars, but and I enjoy helping people. It's nice to give back to the community, and it's nice to advocate for people who may not be able to advocate for themselves.
All right, so next question. Good job, girls, for answering that. I was married in the Philippines in 2005. We separated in 2007. I moved to Canada in 2009, and we have never been together since. I only contact him to sign paperwork for my daughter for the PR application. My daughter and I are now Canadian citizens. Her father is still in the Philippines. We did not go to Philippine court to dissolve the marriage. There is no divorce. Can I file a divorce in Canada? So in accordance with the Divorce Act, there are two reasons for jurisdiction purposes to determine where you can file your divorce. You have to be an ordinary resident of the province in which you are filing the divorce, or both spouses consent. Those are the two issues that you need to determine in order to determine jurisdiction. So yes, I don't see why you can't file it. But ultimately, it's up to the court to grant it. So I can't promise you that the court will grant it. They might ask you to ensure that service took place. They might ask you a number of other things, but there is no problem in filing the divorce in the province that you are a permanent resident in. The only problem that is hard in cases where the other spouse resides elsewhere is the service aspect of it. Not to say that we can't figure that out. We have contacts all over the world, and we do service overseas all the time. So my short answer is yes, and my long answer is you should book a consultation so that we can discuss this a little bit more to ensure that we can get you the divorce that you wish to get.
And to add to that too, it sounds like you can actually still contact the father or your ex. So that's good. Helps you locate him for service if you can actually do the divorce.
Right.
So there's a question that was emailed to us earlier, and I'm going to jump into that. This individual has been or was with their fiance for 8 years. He's from out of the country. She's from Ontario. She sponsored him to come here. There's 2 kids. Throughout the relationship, he pretended like he had no money, although she believes that he might have millions sitting elsewhere. The question is there any way she's entitled to get some of that money for either her children or herself? So typically, courts in Ontario don't have jurisdiction over foreign property. Another thing that I see in this question is that he was your fiance, meaning you were not married yet, and perhaps it was just a common law relationship for division of property purposes. But the short answer is that though Ontario courts cannot and usually don't have jurisdiction over foreign property, they can do what's called an unequal division of property here. If it happens to be that case, if you own a house, for example, here, and the other party has millions of dollars overseas and you don't get a penny of that because it's overseas, a court might take that into consideration when equalizing your assets here. The other second part to that question is about child and spousal support. So child and spousal support is based on income. If your partner has money elsewhere in the world, it might be a little bit difficult to attribute that towards income here. So we can try, but it's not easy to do.
Yeah, but adding on to that, there are jurisdictions around the world that support the Canadian judicial system in terms of collecting and paying child support to a spouse that resides in Ontario. The body that assists in that is the Interjurisdictional Support Unit, and they will assist in figuring out how to get money out of somebody overseas or how to serve somebody overseas, and allow the individual who is in Ontario to get access to the family law court system. However, like I said, it is very jurisdictional specific. It does not, the Interjurisdictional Support Unit does not exist in every country in the world or every city in the world. They are very
specific.
Correct.
Okay, so we have another question here. If a boyfriend and girlfriend buy a house and the girlfriend leaves after 17 months and she had contributed nothing to the down payment, mortgage, or house expenses, however, that individual is still on the deed or on the deed, what is the best path for the boyfriend? Could it include small claims court? Okay, so
There's a lot of questions in that one little place.
Yeah. So I do get quite a few questions about this on the real estate end. So it's more of a real estate question, actually, and a litigation question as opposed to family. I would say that you can't unilaterally remove her from title. So she needs to sign off on a transfer document taking her name off title. So that's going to mean that legally she does have an interest in the property, and you'll need to reach out to have her agree to be removed from title. If she doesn't, that could lead to litigation. And if your costs are going to be below, or if you think the damages are going to be below $35,000, then yes, you can go small claims court. But I would say if you're looking at a house in the GTA, it could be much more than that. So you could be looking at Superior Court as well and bringing an application there. So I hope that answers your question.
Thanks, Barb.
Yeah.
Okay, I'll go. One of the Q&A questions asks, one partner recently left on an adventure across the country, was told that if she left, the relationship would be considered over. The response was, we better sell the house and divide. Within a few days, the partner left. What should the other partner do now? So any of my fellow panelists will agree with me when we say we love separation agreements. If this happens, you contact a lawyer. If it is so that the marriage or the relationship is over, it is best to speak to somebody right away, help ascertain what your rights are, what happens on the dissolution of the relationship, and where to go from there. The last thing you want to do is to, sit and wait and nothing really comes from that. So definitely be active, speak to any lawyer. You can book free consultation. And the first thing that any of us would do would be to suggest reaching out to your spouse and trying to come to a date of separation. And at least that way that's agreed to, and it will not be a hurdle moving forward.
All right, great.
Mhm.
We have another question. It's from Anonymous. I've been married for 16 years. He has hired a lawyer to court order me to sell the house. I caved and listed the house for sale. He now wants me to pay off his car loan from the sale proceeds. Can I make him sell the car, or will I take the house off market? Goal is to close all liabilities before house is sold. Also, what happens if the agreement is not signed when the house sells? Where do my minor kids live? The assumption is equal residence. So there's multiple parts to this. The first thing I'm going to say is that for the house, when both parties are on title, they have the rights to force a sale. So even if you hadn't, as you say, caved and put the house on the market, a court would have ordered you to put the house on the market. So it's actually better for you that you did agree to this, because then you wouldn't have to pay costs. The only consideration they do have is when there are young children, if there's nowhere for you to go and you're nowhere near coming to an agreement, then sometimes judges will order that the house not be sold, but that's generally not the case, because they want the parties to try to settle. Now, if the house sells and there's no agreement, what happens is that the proceeds of the house get held by the real estate lawyer in their trust account, and then the real estate lawyer cannot release the funds unless there's an agreement. Sometimes you can come to agreements on small portions. So let's say there's over 500,000 that's in there of the equity, and you just need some money to go forward on the matter, or to find first and last for a rental. Then both parties can come to an agreement to release a couple $1,000s, up to a certain amount where it wouldn't affect any equalization claim. Where do the kids live? It's what happens where you decide to leave, if you're going to be renting or if you're going to be buying, and what you guys agreed to about how your parenting time is going to be decided. That can be done on a temporary basis while you're trying to figure out all of the monetary issues on a final basis. For the house, for the car loan, so all assets and debts are to be equalized and responsible for by both parties. But usually what happens is that you put your asset and debt to one side. So his car asset and his car loan would be on his side of the equalization payment. So he'd be needing to pay those. Once the house sells and he wants to pay off the loan, he can do so with his proceeds of the matrimonial home. However, it's what was the debt on the date of separation. So that would be included on deciding what the equalization would be. Does anyone have anything to add to that? It's a little roundabout of an answer.
I think
No,
I think that was
good answer.
I don't think that the court would hear a motion on forcing a sale of a car.
I don't think so
I don't
No.
think there would be any law that supports that. For houses, it's under the Partition and Sale Act, and that's why the court has that jurisdiction to do so. I don't believe there's anything for a car to force a sale.
No.
But
Unless
the money, the money would be held in trust. So however the division happens, it can happen at a certain point.
if it was affecting debts and he stopped paying for his loan, and then it was now coming as a creditor to you because he's not paying it, then you might have an argument. But short of that, I don't see it, and I don't think it would. The amount that is owed probably wouldn't merit the amount of costs for bringing a motion.
Correct.
Yep.
All right. Thank you, Emily. Should we take some of the email questions? Because I don't want to be neglecting our previous email questions.
Sure. So I have one, and it's about, it's a little bit long, so I'm going to summarize this to the best of my ability. There's a court order, and it stipulates access for dad to have the child from Fridays to Wednesdays. Sorry, every other Friday to Wednesday, but instead dad is not following this court order. The question is, I get no help from him, from spouse. Do you think I have a shot if I go back to court? So if you already have a court order and he's not following it, you have two options. If you want to change that court order, you can bring a motion to change. And the threshold for a motion to change is a material change in circumstance. On the other hand, you can also do a contempt motion because he's not following that court order. And if you don't want him to if you want him to follow that court order, if you want costs, then you can bring what's called a contempt motion. So those are your two avenues if there's an existing order. If you are concerned about child support, that would also, and if child support has been ordered already, then it would be a motion to change because you would need to change the amount and quantum of child support payable. And you could get that enforced through FRO, which is the Family Responsibility Office. But the FRO will only enforce if there is a court order.
Great. Thank you, Karishma. There's another question from Valerie. She says, we've been married for 43 years. We've been basically living apart but in the same house. We do not agree on a date of separation. And 6 months ago, he emptied our joint bank account that we paid the bills from that and brought groceries. I keep being told that he can't do that, but what do I do about it? $10,000 is gone. He has his paychecks going into a private account, and now I have to use Visa to buy food. My suggestion is that you start a court application. The only way to force something to go forward is through court. You can bring a motion to have the court decide what is the separation date. So it's when parties have been living separate and apart with no chance of reconciliation, but that does not mean that you can't be living in the same house. So things that are considered are the fees, are your finances split? Are you representing yourself to others as married or separated, that kind of thing? Are you living in the same bedroom? Are you still sharing all the family responsibilities with the kids together, that kind of thing? With the money that has been removed, if it was before separation, then you can try to trace it and try to have it come back on unequal division. That is a harder thing. If it was after the separation date, then what is divided is the assets on the date of separation. So you would be getting that money, at least half of that money back in terms of what money is being divided. If he is now not paying some of the bills for the house and you're trying to do that on your own, I would suggest that you bring a court application. Maybe you can sell the house, but you would be accredited for what you have to pay. So let's say that you separated in January, the house sells in June. And only one party has been paying all of the upkeep of the house. So the mortgage, the property taxes, that kind of thing. And if you're both in the house, then utilities, then you are entitled to 50% of that back, and that you would have as post-separation adjustments. Because you're having difficulty right now, I would say that you need to start doing a process to get this started so that it doesn't continue and he doesn't continue to spend the rest of your money.
Thanks, Emily.
Back to email questions.
Sure, I can take one.
Thank you.
All right, so we have here, this might have been referred to by Emily earlier, but is there a time limit to do a division of assets? So yes, you have 6 years from the date of separation or 2 years from the date of divorce. Now this is specific to equalization. So if you are joint owners in any property, you still need to decide how that will be divided and if it will be divided. So I know some couples that continue to remain joint owners on investment properties. And also would like to apply to have a will done. I am 65 plus, so that's totally great. We do wills here at KPA, so you can book a consult with our wills lawyer and he'll be happy to assist.
Thank you. So someone has asked how KPA fees works. I would advise to go over to our YouTube channel, and on our YouTube channel, you will find how legal fees work, and that should describe to you how fees in general work. But if you wish to call us and figure out what kind of service you need, that would be very case specific. We don't have a ballpark figure for every single file. It does become very case specific depending on the type of law and legal services that you are looking for. As I described earlier, there's full representation, there's legal aid representations, there's limited scope representation, there's a one-time review representation or a case assessment. So all of these types of different areas have different types of fees. So if you wish to get your case assessed and figure out how much it would cost you to hire us, book a free consultation.
There's a question here. How do you go about getting the father to pay child support? Also, how do you get the proper amount if he's unwilling to show income? That's a really good question. We get that a lot. And of course, to pay, you need an order for child support for FRO to enforce it. If he's not showing the proper amount or unwilling to show a proper amount, you'd want to first get an order for financial disclosure. If he still doesn't provide that financial disclosure, again, a contempt motion, or second, you can get his income imputed based on, what he does, what he should and has the ability to earn, and assuming he's not, doesn't have an illness that prevents him from working. Judges don't like to see people who are unemployed, underemployed, or, just unwilling to show income to avoid paying child support.
Thank you, Karishma.
All right, so we have another question here. So if the matrimonial home needs repairs, home is just in your name, what happens if I take out sole line of credit or take out reverse mortgage to attend to the much needed repairs? Also, spouse has benefits and I work part-time for a nonprofit. Can I petition to remain on his plan? So to answer the first part of your question, usually when you're taking out a line of credit or getting a reverse or a mortgage for any matter, if it is a matrimonial home, there is typically a need for spousal consent, even if they aren't on title. Having said that, if the bank doesn't ask for spousal consent, you certainly could take out those funds and put it towards the home. But having said that, if you are currently separated, you're looking at the value of the home at that date of separation. You could probably factor in the increase in value after the fact, but I would say that yes, if you can take a loan out, you could certainly do those repairs.
So the second part of the question, my spouse has benefits and I work part-time. Can I petition to remain on his plan? That is determinative. So there's two different parts to it. So with a plan itself, it depends on the plan because they will define who a dependent is. Some plans define a dependent as someone who is separated. Some do not. Sometimes you can have benefits continue until you're divorced, and sometimes as soon as you're separated, you can't have it. It depends if you're married, so you could have him remain on benefits if he's also paying you spousal support. That's a little different. If you have children, then yes, you can have them stay on the benefits. How Superior Court has some of these jurisdictions. Ontario Court of Justice does not have these jurisdiction to order benefits.
Thank you, Emily. The next question I have here is, my daughter is planning on separating from her husband. He is a drunk and takes drugs. They have 4 children. They've tried to get him help. He has no interest in straightening his life. The kids, she wants him to see the kids whenever. She does not want any money for support for the kids. Should they get a lawyer to have an agreement done? So first and foremost, when I read the line that says she doesn't want any money or support for the kids, I always advise my clients not to go that way, because the child support is not the parent's right. It is the right of the child. And no child deserves not to get support to assist them in their life, because even the littlest of money can assist a child in their growing up in the society, get things that they need or whatever the case may be. But I have never liked it when parents say, I don't want money from the other party. Your kids are together, you had them together, You both should raise them. You're both parents to the children. But that being said, if ultimately you really wish to not have support, yes, preparing an agreement is the best course to end a relationship. If you don't, then you leave loose ends. You leave it open for a potentially a future spouse or a future partner to lure your spouse into fighting for things that should have been settled a long time ago. It's better to break the relationship and have a separation agreement put together and end all matters at that one time.
And since he doesn't seem to be interested in seeing the kids, what I would suggest for your agreement is that he can have access whenever requested and up to your discretion. So let's say he is drunk or he is high, then you can say no. Also, you don't have to be, let's say if you put in a set agreement on the times of access, you have to make sure that you and the children are available for that time, even if he's not exercising it. So that's why if he's not interested in it, it's better to have it as up to your discretion as opposed to a set schedule.
So yes, an agreement would be great. Go for it, Karishma.
Just to tack on the child support issue that you were talking about, Preet, just for, a quick breakdown, child support is, basic table amount, food, clothing, and shelter for children. So it is very important, as Preet said, it's not necessarily the party's right, but it is the right of the child. So, double think that before you plan on waiving that right. And if you do put that in a separation agreement, if this ever goes to court, a judge might set that aside because it's not your right to waive.
However, if he has no income, has absolutely no chance of having a job because of his alcohol and drug problems, and he is getting help, that kind of thing, a judge probably wouldn't impute an income on him because
and it's not worth fighting. Yeah, it's not worth fighting for it. It's not worth paying a lawyer to keep fighting for something that you can't get. Yes, there will be a fine line when you should be arguing for it and when you shouldn't be arguing for it. But a blanket provision waiving it is not something that we would advise. And yes, like I said before, an agreement is probably the best course of action because you don't know what the future holds and you don't know what he's going to come back with. And for all you know, he might come back a year from now and say, I want to see the kids 50-50. And you don't want to be put in a position where you might have to agree to something like that at a later point. At least if you have an agreement in place, you've already set the ground down and you said you could see the children on 24-hour notice or 48-hour notice, 72-hour notice, whatever fits your life and fits your schedule. It's on paper, and then if he wishes to change that, he would have to bring a motion to change, and he would have to prove to the judge that there has been a material change in circumstances for why he's requesting the changes.
We have a question from Claude asking us if we all work in the same office. Yes, we do.
Yes, we do.
We all have our own offices, which is why we're on our headsets and mics, but we all are under the same roof.
I think the clue is the matching wall paint that we have behind us.
Yeah.
Yes. So KPA is a firm, and we are, well, not Preet, but we are all employed by KPA. Preet's the partner, and so is Ryan. So they run the firm, but because we are a team, we actually get to have a lot of help from each other. So if you're ever stuck on a matter, or let's say you get called away on an urgent matter, then you have another court date, you have someone who can always step in and make sure that a client's file is properly taken care of. It also helps when we're on vacation. So then we can always have, and if anything major comes up or any urgent thing comes up and we're on vacation, then one of our other lawyers can step in.
And the only reasons we don't have our masks on is because we're all in our own offices, but KPA has implemented a mandatory mask policy. We are required to wear them at any time we are outside of our office and in the common areas to protect our staff and protect anybody who's arriving at our office.
All right. Is there any more questions of the emails one?
Yeah. So there is a question. Yeah. My ex common law and I split just after our son turned 1. He will be 9 in December. I've been raising him as a single mom this entire time with no contact or financial help at all. I've maintained the same phone number, stayed in contact with his sister and parents, so there's no excuse for him not to be contacting me if he wanted to. I understand from family and friends that he lives outside of Canada for at least half of the year. I want to be able to have full custody of my son to make all decisions, as well as to be able to travel with him without my ex's involvement or permission. Is there a way of getting full custody of my son without having to go through a possibly lengthy and costly court process? That's a really good question. So if your spouse has not, or your ex common law partner hasn't been in your child's life for X amount of years, what I would suggest first is to reach out and to avoid costs, see if he will enter into an agreement. Just one quick note on sole custody and being able to travel. Even if you get an order for sole custody, it would still need to explicitly state that you are able to relocate without your former partner's consent, or you can travel without his consent. Just having sole custody might not necessarily give you that unless it's explicitly stated in an order or in an agreement. So first, I would recommend, reaching out, seeing if he'll enter into a separation agreement. You can always file the separation agreement in court should you wish to. Alternatively, we can't force anybody to sign a separation agreement. If he's not willing to engage, then unfortunately your only other avenue would be to bring a court application and go down that route.
Right. So there's another question from Anonymous. Separated for 4 years, but still working on separation agreement and child support calculations. And calculating for last year, it came to light that my ex voluntarily took 5 weeks off without pay last summer, effectively $8,000 reduction in his income. He claims it was needed to care for our youngest child, whom he had for 3 of the 5 weeks, and means that child support payments coming to me was reduced considerably. Can he get away with this? There was no prior discussion. If he sent our child to summer camp instead, the cost might have been a max $1,000. I would make the argument that he is intentionally under earning and that his income should be imputed on what his income should be. And as well, you could also take a average of his last 3 years, which the Act does, which the Child Support Guidelines does allow when determining what income is. So he can fight it. But I would say that a judge would look at that and say, well, one, you only had the kid for 3 weeks, so why did you take 5 weeks? And two, especially if you as the mother have primary parenting and you don't take time off to care for your children, why should he when he's having his access time? When his access was being decided, was it considered that he was going to be taking that time off or not? So he's going to make that argument. You definitely have an argument against that and making sure that his income is what it should be based off of what his salary is or an average of his last 3 years.
Thank you, Emily. Barbara, do you want to go back to the email questions?
Certainly. I think there's another one here that I saw. Okay, so my children are 4 and 6. In our consent order, a clause states that the parent shall review the access once the youngest child turns 5. It doesn't say how we are to review this clause. How realistic is it to bring a motion forward with the intention to increase my access? I currently have about 35% access. So with this sort of thing, you could bring a motion to change, but in order to bring that motion, there has to be a material change in circumstances. But provided that there is a clause that states that creates this contingency, once the youngest child turns 5, you can review how much access you have. You could approach your spouse and have an open discussion or a frank discussion about increasing your access and making that agreement outside of court if you like. Alternatively, you could go to mediation to amend it.
Perfect, thank you. The next question in the Q&A is, my husband wants to separate, but he has been out of work for almost 2 years. Is it prudent for me to hold off until he finds a job? How will child support and spousal support work to my benefit? So as Emily mentioned, just because he's out of work doesn't necessarily mean he shouldn't have an income. So the concept of imputed income would be something that would have to be explored in your situation. And of course, child support and spousal support will depend on what his income is, what his net disposable income is. Is he able to pay spousal support? What kind of income does he earn? What kind of spousal support would be paid? So a lot of questions arise in my own head after reading your question. But in terms of imputing income on him, the courts would take into consideration his education, his level of experience, what kind of jobs he's held before, what kind of income he's had before. and they would likely impute income should he not find a job in the near future, or also look at the fact that what he's doing to not get a job instead of what is he doing to get a job. Imputing income, pretty much. Ryan actually messaged us in our group. Ryan's the other partner at KPA, and he's handling the IT back end of our webinar. That people in the attendees, the participants, may not understand what imputed income is, and of course I can explain that. So pretty much imputed income is when the courts know that someone is either underemployed or not employed at the time being, and they need an income determined before they can award child support or spousal support, or for any purpose where in family court it is necessary to know an income of an individual to determine another aspect of family law. So what the courts will do is they will see what would this person be making with their another individual of their education level, of their experience level, of their age, of their capabilities. What kind of money would this person be making? So take for example, somebody who doesn't have an education, somebody who has been working at a labor job, a Tim Hortons job, or any type of fast food chain, and they decided that they didn't want to work anymore, and so they've been sitting at home not working. And so it comes time to pay child support, and they're saying, we don't have a job. So what the court will do, they'll look at what their past experience is and say, okay, so you worked at Wendy's, you worked at McDonald's, you worked at Tim Hortons, and what is a person in the position of the types of jobs you did, what would they be making? So they would take that income and they would impute income. So it's saying you should be making this much money, and that's why I'm going to take that should be making number and award the rest of the child support, spousal support, or what else not.
So I am going to caveat this is on the fact of COVID-19. We
Correct.
haven't seen it in the courts yet on how this is affecting support purposes, but we can probably assume that it will affect it. Specifically, if someone lost their job due to cuts because of COVID-19, and live and work in an area that is greatly affected by it. There is no case law that we've seen recently about this, because right now they're not forcing anybody on urgent matters to pay support, especially if they've been fired because of COVID. So I do just want to caveat that we don't know how that's going to affect cases going forward. It's also, I have seen it being affecting cases in terms of equalization as well, when parties own their businesses that are specifically tiered to avenues that have been affected by COVID. Things like, theaters and people who are actors or work in restaurants that have been closed, that kind of thing. It can be pretty dramatic, and we haven't seen how that's going to be affected. So it's something to think about when you are thinking, oh, okay, well, I can have his income imputed or her income imputed. It may be caveated in the future. We just don't know yet.
Thanks, Emily. So going back to the emails, there's an email as well as a chat, and they're both asking the same question. So I thought this would be a good opportunity to do that. My husband and I recently separated. What are the guidelines for being separated while living in the same residence? I think we touched on that a little bit before. When I am financially stable to move out, what happens to our matrimonial home, and am I entitled to spousal support? Another attendee has asked, if my wife has a job but her salary is 2/3 of mine, do I need to pay her spousal support? So spousal support is not like child support. It's not an automatic right. There are, there's a test. You have to first prove entitlement to spousal support. And then there's the question of the quantum of spousal support. So just being married doesn't automatically afford you that right to entitlement of spousal support. There's different types of spousal support. There's compensatory, there's non-compensatory, there's contractual spousal support. So spousal support's a very different game than child support. Another question was, how's child support calculated? Child support table amount is calculated based on payor's income, what province you're in, and the amount of children you have. If you have 2 kids, 3 kids, et cetera, et cetera. So that's how child support is calculated. Where spousal support is a little bit different. Like I mentioned, you have to prove entitlement first and foremost, and then it's a range. It's not just a number that can be quickly calculated. The second question of that question was, what happens to our mat home? I believe this was touched on earlier, but if it's a matrimonial home, it only takes one party to seek the sale of the home, and the home will be forced to be sold, or so listed for sale. And that's because both parties have that equity in that home. It's their asset jointly. Both parties have a right to that. So if you sell the home, of course, as Emily said before, the proceeds get held in trust and then divided pursuant to, an equalization claim, but typically 50-50.
I'm just going to add on to Karishma with some plain language, because she was using legal terms for definitions of spousal support. So contractual would be, let's say you had a marriage contract or a cohab agreement and you contract it. In that contract, you said one party will be paying support of the other. So that's one of it. There's compensatory, and this is to alleviate some of the economic burden that was on a spouse because of the choices that the family made. So think about a wife who has 2 children, and as a family you decide that she's going to be taking the mat leave. She's going to be taking a couple of years off to help raise the kids while dad is working full time. The fact is, yes, this was a decision in the marriage, but it was decided that she's now taking time off and she's not growing in her career, which would increase her income potential. So that's compensatory. And again, that can be either or, husband or wife, or whatever your relationship is. Then there's non-compensatory. Now this is what's called needs-based. So when one party, when they separate, cannot afford their required monthly bills. This is where, usually it's when one party has had a significant more income than the other, and when separated, they cannot afford any of their bills to be living on their own. So it's non-compensatory in order to force spousal support for that type of scenario.
To add on to that, Emily mentioned needs-based, but there's also the payor has to have the means to pay. So it can't just be, I need the spousal support, but my spouse also is unemployed, not on, their own, but for other purposes. Of course, then they don't have the means to pay. So it's needs-based, and as long as the payor has the means to pay. And Emily thank you for breaking it down for compensatory.
Okay.
All right, so we have a question here that I can address. Let me just pop it up. Don't mind me. All right, so it's from Anonymous. Husband and wife had a rental property during the marriage. There will be capital gains on that property, which the husband moved into upon separation. Who pays the capital gains tax, and when is it payable? Okay, so for those that might not be familiar with this, capital gains is the increase in value of a property, and it can be taxed upon the sale of that property. This only ever occurs when the property is sold. You typically report the sale of a property in the year that it was sold. So if you sold a property in 2020, you report it on your income tax for 2020. Who would pay the capital gains? So in this situation, because it was a rental property, if you're selling the property as a way of getting out of or dealing with your assets in the marriage, I would say you split that capital gains, unless, because currently if you're both on the property and you're earning interest on it as a rental property, you both are benefiting from it. And you can't be earning interest, or you can't be earning income while your husband is in the property. If the property is being retained by the husband and it's retained after the separation, and agreements. That house could still be taxed for capital gains. It would just be dependent on how many years it was a primary residence, because there is an exemption for capital gains when it's primary residence. How many years he would live in it as primary residence versus how many years it was lived in as an investment property. So I would say yes. Who pays capital gains? Both of you, if you're selling it at the time of separation, and that capital gains tax is payable the year following the year it was sold.
So next question, there was a no contact order in place, so I'm the one in contact with my grandson's mother. We had a great relationship previously, however, being the messenger between my son and her has been very trying, so needless to say, our relationship is pretty much non-existent. My question is that she's been calling me B in quotations and telling me to blank off, and now she told my grandson she hates me. Oh my God. My question is, how does the court look at this behavior?
I have to say thank you first for taking the words out.
Yeah, probably would have just read it if it wasn't there.
Yeah, I know.
So the court will look at this behavior, especially if it's documented in writing. It's harder to take it into consideration if it's just hearsay. But since it would be your son's court matter, if you want to put this in, then you can write your own affidavit as to what your experience is with the mother has been as the mediator between the two parties based on the no contact order. The court will look at which parent is supporting the relationship between the other parent. So it's not determinative, which means that it won't be just decided, if she's not refusing access or if she's refusing to talk to you, that kind of thing, then it doesn't mean automatically that he's going to have the access that he wants or that she won't have the child anymore. It's not what I'm saying, but it will be considered. And to the amount that is affecting the child, that's when it's going to be considered more by the judge. So the fact that she's now saying things to your child, and especially depending on how old your grandson is, that could really be taken into consideration.
Thank you, Emily. The next anonymous attendee I have here is I lost the question. I've been working at my job for 15 years. I was married to my ex for 10 and a half. I have a pension and my ex does not. She is self-employed, owns her own business. When we first separated, we discussed leaving my pension and her RRSPs / investments alone, not including them in our division of assets. Now she wants to divide everything in half. How does this work for her business? So for businesses, what we like to do is get an evaluation done to determine the value of the business so that it can be included into equalization. Given that your marriage was, you were married for 10 and a half years. So 10 and a half years is a considerably long marriage, and your pension would get divided. RRSPs would get divided. Investment would get divided. But the business would also get divided. The value of the business would get equalized, and you would get a portion of, and perhaps that portion could be in your pension. So you say, don't touch my pension, don't give me the extra money, but my pension will remain the way it is. So you can equalize things in different manners. It doesn't have to be cash in hand division. I hope that answers the question. If anybody else wants to add anything. All right, next.
All right.
Karishma, is there any more in the emailed ones?
Let me check. There's a question about child support for a student under the age of 25 still attending university, whether or not that child is eligible for child support. So again, I think we touched a little bit on this earlier, but in case we didn't, post-secondary education is considered Section 7 expense. So as long as it's a full-time program and it's the first one, it used to be that child support ended as soon as the child turned 18. That's not really the case anymore. There are several factors that we take into consideration. By we, I mean the courts. And if it's a part-time university program, it's likely that you're not going to be that child will not be eligible to attract child support. But if it's the first full-time program and it's the first full-time post-secondary program, or even as Emily said earlier, if both parents are, for example, doctors and the child later decides they want to be a doctor and continues further education, there might be exemptions for that. But I hope that answers your question. If child support is still available for a child under the age of 25, as long as they're in a full-time first university program, then the answer would be likely.
Great. So another question, can you give an example of how to be indemnified from a spouse's personal debt? I have not signed any credit agreements with him or his annual income is 5 times mine. When you're married, you are responsible for each other's debts. Doesn't matter if they're personal or not. You can always contract out of that by doing a marriage contract that says everyone's personal debt is their own. And you put in that contract that if it is not paid, then you put in the word that spouse is indemnifying the other one. What that means, it says that although legally a debtor can go after the spouse, if they do so, then the spouse whose debt it is has to pay for that, and usually also pay for their legal fees in order to defend against having to pay that debt. You see this a lot in marriage contracts. You also see it a lot in separation agreements. I personally always put it into mine, even if there's no personal debt. I will still say in the agreement that each party is indemnifying the other of any debts. So no matter what, if after the separation there is a claim in civil court over a debt, then you can show the agreement and show that the other party has to indemnify you. It doesn't stop you from being sued, because no one can really stop someone from suing someone else, but it is a defense.
Thanks, Emily. So there's another question. Does the house that is paid off have to be sold, or can I buy him out? That's a good question. It's not necessary that it's if one party doesn't agree to a buyout, then yes, the house will be sold if it's a matrimonial home. But that doesn't mean that between the two parties, you can't agree to a buyout. So you have that option. But in the event that the parties are not in agreement, unfortunately, selling will be the only option.
And the selling is under the Partition Act.
Correct.
And for the second part of that question, says with our investments, just make sure that you're also counting those investments to be equalized. So you would only have half of that in order to do the buyout. All right, Bernice has her hand up. Brian, can you let her in? Hi, Bernice, you just need to unmute yourself.
There we go.
Perfect.
Hi, Bernice.
Hi, I've been enjoying listening to you. There's just everything seems to all be about situations with having children at home, or I guess most of the fights between people breaking up are between kids, right?
That's what it seems like. Yes, you're right.
Yeah, my question is regarding two adults who've been living common law for many years. What rights does one partner have, or against the other? What rights does each other have in if it's strictly common law relationship?
So we talked about this a little bit. So strictly common law, there's no equalization rights, but if you have shared title on anything, then that would be divided. And then if you don't have shared title, but you've been contributing to some form of asset, then you have a joint family venture claim for part of that asset. It doesn't have to include children. It's just if there are children, then it's something that is considered. But if you've been doing all of the upkeep of the house, like you're not on title, but you've been doing all of the upkeep, you did all the repairs, you've been making sure that it's maintained and cleaned, all that, did all the gardening, that kind of thing. Those are all considered as part of it. Children are a consideration, but it's not a requirement in order to make a joint family venture claim.
They had one child together. The house is in strictly one partner's name, the deed, and he's been making all the mortgage payments and all the utility payments, and on the house, property tax, and all that.
Mm-hmm.
And her role has been, looking after groceries. They've had other family members living and pitching in, everybody buying groceries. And her money basically allowed them to have a little extra money to go on vacations, do few things that they probably wouldn't be able to afford otherwise, because his schedule would be pretty, his income would be very, very tight, just paying all the basics and main part of the financial affairs. there is one child, excuse me, who is now 19, and he started university last year. Of course, he's off now with COVID, but hopes to go back again. So he said he's 19. I know, I don't think they're, the child support on either party. I think they both love their son very much and both contribute that way, in helping out. But with not having any, with being strictly common law, is there any separation papers required, or what should they do to just protect each other?
You should do a separation agreement to protect each other, to however it is that they decide to split the asset. It doesn't sound like she'd be entitled to 50%, but possibly something. The child is 19, but there's also Section 7 expenses, which includes his tuition, that it's best to have it in writing so that you don't become a fight later when the money is due. And then you're trying to pay it when the school needs it to be paid. Also, the concept of spousal support does come up with common law spouses. So if one party makes a significant more than the other, they've been together for a long period of time, and all the other considerations that Karishma talked about with spousal support, that could be an issue in this matter. So either they should come to an agreement about what spousal support would be, or do spousal support waivers.
Okay, so even though they've never been married, an agreement, you'd still have a separation agreement, just
Yes.
because of, even though it was common law.
Yes.
Okay, so a lawyer's advice to start with would be a good thing, I guess.
Yep. Get her to
And
call us and set up a consult.
Yeah, she's left already. We don't know, what her intentions are coming back. When we hear different stories that she wants time out, break time, may or may not come back, but that could go on indefinitely. And because of where she's gone traveling and abroad right now, she could run up like literally thousands of dollars on this trip. So,
But they're common law, so he wouldn't be responsible for her debts.
okay. And so I guess, again, a separation date set in place as quickly as possible, so that as of this date, they were separated.
Yeah, it doesn't have to be agreed. Like if she's left and there's no relationship from that day, it's a pretty good example of what a date of separation would be. But to try to get it started so that he's not trying to chase her later on and try to find her, because you're going to need her cooperation to do a separation agreement, or you're going to need to find her to serve her if you need to do something for support basis for court.
I think the biggest concern is, is she, can, and if or when will she come back wanting part of, half of the house kind of thing.
Which is possible. So if she come to an agreement that she's not entitled to any of it, or only entitled to a part of it, that means when she signs that agreement, it's very difficult for her to come back after and say that she should be getting more, because she's going to have to prove that the agreement was signed improperly. And there's a few different ways of doing that, but it's pretty hard to overturn an agreement.
Can she still force him to sell his house?
If she's not on title and they're not married, I don't believe so under the Petition Act.
Yeah, she's not on title. But if I guess that's the question, will they get an appraisal, see what the house is worth? Would he need to give her a payout in order to be able to keep it?
Yeah, that's the best way of doing it. And then she wouldn't be directly entitled to 50%, so it would be a discussion about what her contributions would be a percentage of the home.
Okay. Yeah, because she's had some pretty good jobs off and on, but she's had a lot of times in between her jobs not working. And, she wasn't required to be at home. They had babysitting was never an issue. Okay. All right. Thank you so much.
You're welcome.
Not a problem.
Brian, thank you.
So there's another anonymous attendee that's asking, can a separated couple make their own separation agreement, then go to a mediator lawyer to finalize it? It's very difficult to make a separation agreement on your own. because chances are you'll spend time making a separation agreement and then you'll go to a lawyer and a lawyer will put in a number of clauses that you probably have not thought of. So the best course of action is prepare something. Of course, it's easier for a lawyer to work from if you prepare something in bullet point as to what you want to do with the children, what you want to do with the division of assets. Fill out a financial form. You can find one online. It's a Form 13 or a 13-1, depending on what kind of assets you have. Fill out as much as on the form, get all your documents together. And then at that point, once you have all of that together and you go to a lawyer, it will cost you a lot less than what it would have had you just gone to a lawyer and started by saying, can you draft me something? And then you would have to figure out what you want the lawyer to draft. So as lawyers, what our job is, we advise you, we tell you what the law is, but ultimately it's your life. You need to tell us what you want to do with your life. We don't tell you how to move on with your life. What we do is we give you your options and you tell us what option you wish to proceed with and how you want us to help in proceeding with that option. So short answer, don't draft your own separation agreement because it can be set aside later on if it's poorly drafted. And you may not even protect all your rights by drafting your own separation agreement, but do prepare a story per se, or a bullet point document that states what you want to do in your separation. So what we like to call it is the kitchen table discussion. So you sit with your spouse or your common law partner and you discuss everything about your marriage and how you want to move forward and what you want to divide. And then you come to a lawyer and a lawyer can draft it for you.
And especially what I ask my clients to do is talk to their spouse about the access and parenting time and holiday time. A lot of people don't think about how they're going to split the holidays. You know, we can set it up so it's 50-50, but we don't know your life. We don't know what holidays are specifically important to what parent or the other. So if you already have that, that's going to save you money so that the lawyer doesn't need to draft it up.
So when I said the word set aside the agreement at a later stage, what that means is, again, my dear business partner, Ryan, has messaged me and said, set aside, what does that mean? So what that means is that if your agreement isn't in writing, isn't properly drafted, isn't witnessed, and you don't have independent legal advice, which is pretty much meeting with a lawyer and discussing everything that is in the agreement to ensure that you know what you're signing. If any of those things are missing and the opposing party wants to contest, meaning the opposing party doesn't agree with your agreement at a certain point in life, and usually that happens years from the time of the agreement being drafted. Actually, that's not correct. It can happen immediately after signing the agreement. The opposing party can take that agreement to the court and say, Your Honor, this isn't a binding agreement because something was missing, independent legal advice was missing, and what the courts will do is set it aside. So what that means is that the courts will pretty much say this agreement probably, they'll put it in a way that this agreement never existed, so let's start over, and then you're stuck in a situation, or they might set aside portions of the agreement that aren't valid or that shouldn't be valid, or it's questionable whether those items in the agreement were agreed to with the correct knowledge of what you were agreeing to. Happy, Ryan? I explained that concept.
So Ryan is a civil lawyer, and that's why we need his help to tell us when we're speaking family law legalese and not explaining plain English. Thank you, Ryan.
That was very clear.
There's an email. Emily, do you mind if I
Go
jump
for it.
in? Okay, so they've been married for 34 years, no kids, own the home, the house and vehicles are paid off. He's a semi-functioning alcoholic with a drug addiction, has been for years, wants to know the steps she needs to take to start the separation process, but cannot leave the home. So to start the separation process, it's, you just have to, of course, establish a date of separation. You can do that either amongst yourselves, or it might be a little bit more complicated than that. But definitely what you want to do is reach out to a lawyer. And it's really important. The date of separation is so important to establish right away, because like we mentioned earlier, sometimes it's what it can cost a whole lot of money if one party alleges a date of separation and the years are apart. The date of separation or years apart, because the date of separation establishes equalization, and it establishes if spousal support and when spousal support will commence if you're entitled to it. So definitely what you want to do is start gathering your financial documents. That's the number one thing we usually tell our clients, which, like Preet said, it's a Form 13 or Form 13.1, depending on your assets, and start organizing your financial disclosure, because that's typically the number one thing we start with when we commence a separation, whether it be a separation agreement or an application in court. In terms of the home, like we mentioned earlier, unfortunately, getting exclusive possession of the home is quite difficult. So if it's about home, you would, of course, it would either be sold, or if he agrees to a buyout, then you can buy him out. But those are your options with respect to staying in the house.
Thanks, Karishma. So there is a question that has to do with criminal law. So I'm going to take that, as I also practice criminal defense. It says, my wife and I have recently separated, and she's trying to have me charged with assault, sexual assault, and mischief under. I'm not sure what you mean by trying to have you charged. If she's gone to the police and the police haven't charged you yet, then you don't have any charges, but they could be trying to build a case and you may be charged in the future. He says that the assault and sexual assault are fabricated, video proof of her emotionally and physically abusing her. It is not a defense in criminal law to have been provoked in general. If you have touched her when she does not want to be touched, it doesn't have to be a punch, it doesn't have to be a kick, any of that kind of stuff. If you have touched her when she does not want to be touched, it is an assault. So sometimes this video proof is not actually helpful. If she is also physically abusing you, which seems to be what's happening, then you could go to the police. This kind of thing does take into effect in family law when determining custody and access. However, it almost never has any merits when you're dealing with equalization or spousal support, because we're no fault jurisdiction. So the actions of another party is not taken into effect on the monetary issues, except in very, very small situations where an unequal division could be made, or an order for no support could, or some support on a smaller amount could be made. But these are significant types of arguments that are very, do not happen very often, especially if there's not actual evidence of the abuse. So if you have further questions about possibly being charged, you can contact me for a free consult on the criminal side.
Thanks, Emily.
Thank you. We have a question if we're seeing courts modify determinations outcomes because of COVID-19. I haven't really seen any on a final basis, and anyone else can interrupt, but it has been happening on a temporary basis, changing access if one parent is being unreasonable, not following government protocols for COVID, or if they haven't been able to pay support. The Family Responsibility Office has not been enforcing. That may change soon with things opening back up, but right now they haven't been enforcing court orders or doing enforcement proceedings. They've been collecting the money, but they haven't been doing enforcement proceedings, i.e. taking away driver's licenses or your government money, any of that kind of stuff. We haven't seen the long-term effects yet because we're still in the midst of COVID-19. So we'll see how that goes.
Yeah, very true.
There's a question on the Q&A. It's a common law question. We lived together for 6 years. Then she left for 5 months, then returned, then left after 10 months. How does this fall under continuously? So this is a question we usually get, and we have in our separation agreements when partners are in fact married, and the reason being is because with married spouses, there are equalization claims, as we've mentioned before. In terms of if you were in a common law relationship, it doesn't really, and my fellow panelists can jump in here, it doesn't really change much if she comes back and then leaves, unless you were paying her spousal support in the beginning and then she came back. But this would be a different scenario if you were married and there was 2 dates of separation. I'm not quite sure what the second part of this question is. How would I owned the home outright before we cohabited? If one of you guys can offer your insight as to what that's asking, that might be helpful. Because I don't know.
Yeah.
That the person owned the home before cohabiting. Sorry, we don't mean to laugh at the question, but Ryan just sent us a picture of a
Of me.
zoomed in image of Barbara thinking,
I squint.
and hence our laughing. So
Now
well,
we're all making the Barbara face.
I'm still making the face. Okay, let's see.
So I'm
if
not
you
really sure.
I think it just means, would this change if he owned the house outright or if he didn't?
Before you, but
Before
again,
you-
it's a common law.
The common law doesn't really matter.
Yeah.
so
If
let's
she's
leave
on
it at,
title, then it would change.
yeah.
But
so let's leave it at, if any clarification is required, just book a free consultation with us. We'd be happy to speak to you and clarify your questions.
Yeah.
all right. So one of our other questions is, my mom gave me monies to invest in stock shares and I opened a separate account. If I divorce, will my husband be entitled to the half of the stock investments? Gifts are excluded. However, you need to prove the gift. The fact that you've kept it separate is definitely very helpful. But having some form of documentation that shows that it was a gift is going to be key, so that it can be excluded, so that your husband wouldn't get a part of that. Usually when there is money that is given within a marriage from a family member, it's considered that it's a gift to both parties. So you want to make sure that it is clear that the gift was only to you and not to your husband.
Correct.
Thanks, Preet.
Oh, no problem. Anonymous, I have been separated from my ex for 4 months. She is in a relationship and has asked that she be able to tell our 3 young kids about it. I think this is a mistake and much too soon for all of us to deal with. What are the rights in this? What are my rights in this decision, as well as introducing her new partner to our children now and moving forward, as long as we live under the same roof?
That's a good question.
Very
Yeah.
good question. It's more of a personal question than a legal question.
Typically, I'm going to jump in. Typically, courts don't really, repartnering or remarrying particularly does not really affect much, legally speaking, with the exception of maybe spousal support. But in terms of how you want to parent your child and whether or not, I mean, what I would ask is, how old are these children, right? Because we don't have that information.
Yeah.
But this is not really a question that's governed
By law, no.
Yeah.
I've dealt with it a few times. If it's generally an issue with the new partners, then they're
2, 6, and 9 years
269.
old.
Okay.
Thank you.
Generally, when there's going to be an issue, I try to put that into the agreement, where you can come to an agreement about when you would do and how you would introduce new partners. Specifically, when you're still living in the same house, that would be a little awkward.
The courts will give some guidance if you were in court. I'm not sure if this matter is in court. At conferences, some judges will provide some insight as to what you should do, but it's not legal insight, it's personal insight. And some of the things to consider are, is this a serious relationship? How many other partners have been introduced to the children? Because it causes, it's not in the best interest of the children sometimes to be introduced to a new partner every other month or whatnot, right? So it is personal to you. It is personal to the fact that you're not comfortable, but it is also something that you are living under the same roof with your partner right now, or ex-partner right now, and it is something you can possibly control while the kids are in your care. Again, like I said, it's a personal decision. Courts will comment on it, but to the extent of it, not legally comment on it, only in a conference per se.
They won't order something
No,
on it.
no order, just comments.
Yeah.
I hope that helped.
So we have a couple final questions before we end. We're going to be wrapping up it.
We
We
also
have
Have a hand
Oh.
up.
Sure.
Yeah.
Christine. Ryan. Thank you. Christine, you're still muted. Christine, can you hit the mic button on the bottom left of your screen?
Oh, yep.
Okay. Well, let's take another question while Christine tries to figure out if she can unmute herself. There was a question about, can you comment on garnishing wages generally? How is it generally implemented and how is it administered? That is through the Family Responsibility Office, or as we've been calling it all evening, FRO. So after there is an order for support, it goes to the Family Responsibility Office, who it's up to them how they are going to collect that money. If they can just on their own do garnishment orders, so that they could just start, they just do a letter to your employer and then start garnishing it because there's already an order for you to pay.
Yeah, just to add on to that, the order for FRO to get involved is very specific, and if you don't get those orders put into your family law order, FRO will not get involved, and you will have to go back to court to get those orders put in. So when you are at the point where you're settling the file or coming up on the conclusion of child support, spousal support, or whatever type of support, Section 7, make sure that the provisions that are required for FRO to get involved are indeed in writing in the order. We have Christine.
Christine, are you there?
Christine, your mic is unmuted, so you can speak.
Oh my God.
There you go.
There we go.
The trouble is, I'm not asking any question. I'm listening in, and somehow it goes from mute to unmute, and I'm not touching anything.
Do you have a question to ask?
No, I came in late, and I'm just enjoying the discussion.
Oh, okay. You put
Thank
your
you.
hand up, so that's why you were added. All right. Ryan, can you? Thank you.
Thanks for coming.
Thank you, Christine.
All right, so we're gonna wrap up. Thank you everyone for coming in and listening. As we've said multiple times, if you have further questions or you want to know about how to retain or what our fees would be for your specific matter and how retainers would work, please go on our website, or you can call in and book a free consult with any of. You can either just pick free consult with Family Lawyer, and it'll go through to anybody who's available. Or you can pick on a certain lawyer and decide if you want to talk to them specifically.
I'm sure Ryan will be sending a link to all attendees.
Yes, Ryan will be doing that.
And if you've had a pleasant experience today and you've had your questions answered, if you can leave us Google reviews, that would be wonderful. And I believe Ryan will be sending out a mass email to everybody who's attended to leave us a good Google review. Our business thrives on Google reviews, and especially during the pandemic, it's been Google reviews have been helping.
All right. Thank you so much to everybody.
Thank you, guys.
Thank
Have a good night.
you.
Have a good evening.
Have a great weekend.